Okay, in this video I'm going to take a look at evidence in civil legal actions. Now, I'm going to cover the rules of evidence in broad strokes, the essentials in relation to legal proceedings, but the same sort of principles would apply in the Workplace Relations Commission or the Labour Court, or indeed in other tribunals where a person's livelihood, for example, might be going to be removed, for example the medical council or some place like that, some professional body. Ultimately the rules of evidence and the principles surrounding evidence are similar across different fora, but the application of the rules of evidence in a court situation is going to be more strict than it will be in the WRC or Labour Court. But in any event, it's no harm for you, certainly if you are involved in court, but more particularly if you're involved in a WRC case or a Labour Court case. It's no harm for you to certainly understand what are the principles of evidence and what is evidence in civil cases. So let's take a look. As I say, evidence is going to apply in civil court, it's going to apply in the Workplace Relations Commission, the Labour Court and other non-criminal tribunals. The court obviously has its own rules in relation to evidence and what's admissible and what's not admissible and so on. The other bodies that you see there on the screen, the WRC and the Labour Court and any other tribunal, may have slightly more relaxed rules in relation to evidence and what can be used. But as I say, the general principles are the same fundamentally. So what is evidence? Evidence is essentially facts in issue which are relevant and admissible in a court or tribunal, which tend to strengthen or weaken a party's ability to discharge his burden of proof. Now, that essentially means that if you claim, for example, at the WRC that you had no choice but to leave your job and you've brought a claim for constructive dismissal, then obviously you need to show evidence, you need to show facts from which one can deduce that you have met the burden of proof. You have to prove you had no choice but to leave the job because of the unreasonable conduct of the employer and so on. It's one thing making assertions and making sweeping statements, it's another thing providing the evidence. So that's essentially where evidence comes in. It's the facts that you need to put forward from which a reasonable inference can be drawn, which will strengthen your case. Or if it's the other way around, you may be defending a case, you may be putting forward evidence to weaken the other side's case. The standard of proof in a civil case is on the balance of probability. The standard of proof in a criminal case is beyond a reasonable doubt. So there's a big difference. On the balance of probability is what you're looking at in the WRC or the Labour Court, or in a civil dispute, for example a debt collection thing or a personal injury case or a negligence case, a breach of contract. The balance of probability is the standard of proof that's going to be required in those cases. There are 5 broad categories of evidence. There's direct evidence, that's sworn testimony of a witness. So a person gets into a witness box and is sworn and gives evidence on oath. Similarly, they don't give evidence on oath in the WRC or Labour Court, but direct evidence would be the sworn testimony of the employee, or not the sworn testimony, the oral evidence, the direct evidence of the employee or the employer. There's no oath, there's no swearing on oath in the WRC or in the Labour Court. But obviously an employee or an employer or a financial controller or a HR person or whoever is going to give direct evidence. Primary evidence then is an original document. So that could be, for example, the original contract of employment. Secondary evidence is a copy of an original document. Thirdly or fourthly then, real evidence is a material object produced in court for inspection. So this would be more in a situation, for example, where there may be an alleged assault or something may be thrown into somebody's garden or something of that nature, and the actual real evidence may be produced in court to indicate or to support a particular claim that somebody perhaps threw a shovel or something across into the neighbour's garden in a dispute. Circumstantial evidence then. There's a lot of controversy always about circumstantial evidence, and it's certainly a lesser type of evidence, but nevertheless it can be very persuasive and essentially it is evidence of relevant facts from which the existence or non-existence of a fact may be inferred. In other words, it is circumstantial insofar as if you look out the window and you see puddles everywhere, you don't have evidence so much that it has rained or is raining if it's not raining at the moment, but clearly you can draw an inference that it has rained in the recent past, particularly if there's puddles still out in your driveway or on the street or wherever. So that's circumstantial evidence. Again, if you see some man or woman walking from the scene of a crime, for example, with a bloody knife, and you go in then to perhaps a room in a house and discover that there's somebody with a stab wound to the chest, well, that's circumstantial evidence. You haven't seen the person wielding the knife or using the knife, but a court will draw certain inferences from that. Now, in a criminal case like that, the standard of proof is beyond a reasonable doubt, so there may well be doubts put in the mind of either a judge or a jury in that particular case, but that's just an evidence, or an example rather, of circumstantial evidence. As I say, there's two types of, or the burden of proof then, when you look at the burden of proof, there's two types of burden of proof. There's the legal burden, and that's borne by the person asserting a fact, and in a civil case the standard is on the balance of probability. So if you claim that you were unfairly dismissed, or you've walked out of your job and you've had to leave it, or that you were bullied and you've suffered an injury as a result of that bullying, and you've now got a psychological or psychiatric injury as a result of the negligence of the employer and the bullying that was allowed to go on in the workplace, then you have a legal burden, and you must prove on the balance of probability that you've discharged that legal burden. An evidential burden then is the burden on you to show sufficient facts to persuade the judge or a decision maker, for example a WRC adjudicator or the Labour Court, to make a favourable finding, that is, a finding in your favour. How can evidence be adduced? It can be adduced orally, that is on oath in court, or orally in the WRC or Labour Court without the necessity for oath, or it can be done in writing, that is by affidavit. An affidavit is a sworn statement of somebody's testimony. What facts can be adduced in evidence? There's two broad criteria by which facts are judged. One, are they admissible? So hearsay is excluded. So if Mrs. Jones says that she heard Mrs. Gorry saying X, Y and Z, that's hearsay and it's excluded. However, if Mrs. Gorry comes along to the case and gives direct evidence as to what she saw, well, that's clearly admissible. Facts also must be relevant. So the criteria, facts must be admissible and they must be relevant. Certain facts may have privilege and cannot be introduced. For example, discussion between solicitor and client, because the solicitor-client privilege. There's privilege against self-incrimination. You don't have to incriminate yourself. That's why in a murder or a criminal case, for example, on many occasions the accused person will not give evidence. They will not go into evidence because they may incriminate themselves, and the safest thing is not to give any evidence and let the other side, the state generally, prove beyond reasonable doubt all of the aspects of the crime. Without prejudice, communications then is privileged and cannot be used. So without prejudice, communication would be communication letters, for example, from one side to the other in an attempt to compromise or settle a particular dispute. It also arises in a case where contracts have been issued for the sale of property, the purchase of property. Everything is without prejudice and subject to contract, and contract is denied until there's a binding contract in place, and that it only occurs when both parties have signed the contract. Excuse me. Opinion cannot be used, or is are not facts. Does not give is not evidence. Now, you may get a professional opinion, and I suppose to a certain extent professional medical reports, for example, or psychiatric reports, etc., are used in evidence, but it's important that the person who makes the report, who gives the opinion, it's important that they can be questioned and challenged under evidence. Where are we now? Yeah. So evidence in personal injury actions then is a slightly different situation. There are statutory rules about disclosure in personal injury actions, and there are penalties for anyone giving false or misleading evidence in personal injury claims. Affidavit evidence, as I say, is a witness's sworn evidence in writing that must comply with the rules of evidence. That is, the facts averred in the affidavit must be admissible and relevant and not hearsay. Evidence at trial then can be examined in 3 ways. Now the same thing applies to a certain extent at the WRC or Labour Court. You have examination in chief, that is your witness. So if you are giving evidence yourself, for example, you're running your own case at the WRC and you are claiming you're constructively dismissed, you're going to give your own evidence, but you will be, or you may be, cross-examined depending on the adjudicator's view as to how to run the hearing. You may be cross-examined about your evidence, and you may get the opportunity to cross-examine the other side's witnesses as well. What you want to try and do with the cross-examination then is to impugn the credibility of the witness and to challenge the evidence. That's in broad brush strokes. That may not occur though at a WRC or Labour Court, because you may not be allowed to cross-examine, because the WRC, apparently it's been confirmed by the Supreme Court, is not an adversarial setting or body, but it's an inquisitorial body. So, some adjudicators allow cross-examination and some don't. Re-examination then is just your witness again. So if you're in court, your witness is going to give evidence, he or she may be cross-examined, and you may re-examine your witness again in order to bring out some points or clarify something. Destructive cross-examination then, as I say, what you're looking at there is looking at the credibility of the witness, and you're looking at the competence of the witness. My name is Terry Gorey. As you can see, my contact details are on the screen there. I hope you find this video useful. If you do, you might give it a thumbs up down below, and you might be interested in subscribing to my YouTube channel. The key thing though to do with evidence is that you will need to put forward evidence, whether you're in court or whether you're at the WRC or whether you're at the Labour Court. You can make sweeping assertions, you can make all sorts of claims, but at the end of the day, the rubber is going to hit the road. You will have to put forward evidence, and evidence is facts which will basically support your case. Hope you find it useful. Thank you. Give it a thumbs up down below if you do. Thank you.